We are live. All right, everyone, welcome back. 1:15-ish on the 6th of February, and our post-lunch work is going to begin with a flyby on H578, an act relating to penalties and procedures for animal cruelty offenses. We have the lead sponsor and counsel with us, and we're going to start off with the lead sponsor, Representative Krasnow. Good to see you, Representative.
You too. This is my first time before your committee.
You haven't gov-opped before?
No,
All right.
I mean, I hang out,
I know I see it, Rosie.
but this is my first time. So for the record, Representative Emily Krasnow, Chittenden 9 South Burlington. And thank you to the honorable committee members for having me today. So I'm just gonna not take up too much of your time and do a brief kind of intro on why I introduced this bill, and then Eric's gonna talk about the sections that pertain to your committee. So thank you for the opportunity to speak before you today. I'm here to talk about H578, which addresses animal cruelty and the penalties for those who perpetrate such heinous acts. As someone who grew up in Vermont, surrounded by animals and raised by a single mother, I understand the profound connection between humans and animals. My mother, despite the challenges that she faced, always found room in our hearts and home to adopt animals in need. We frequently took in dogs, farm animals, and others who deserved a second chance at life. I remember the joy of having up to 6 rescue dogs at once, each one a part of our family, each one deserving of safety, love, and care. This experience shaped my view of animals as being worthy of our protection and compassion. We must be the voice for animals who cannot advocate for themselves. As a society, we are their voice, and it is our responsibility to protect our most vulnerable who are unable to defend themselves. This proposed bill is important because it addresses both the immediate suffering of animals and the need for lasting change. It proposes stronger regulation on future animal ownership, which prevent individuals continuing to exploit or harm animals. We must recognize that animal cruelty is not an isolated issue. It often connects to larger patterns of abuse that affect both animals and humans. And it is vital that we not only prosecute animal cruelty, but also take measures to stop future abuse from occurring. H578 represents a chance to ensure that animals are treated with dignity and respect they deserve. It will provide the necessary legal framework to hold abusers accountable, prevent further cruelty, and protect animals from suffering at the hands of those who should not be caring for them. I urge you to support this bill. It is not just about the animals. It is about creating a society that values compassion, respect, and justice for all living beings. Thank you so much for your time and consideration of this crucial legislation. And I'm so grateful for the work that your many committee members have done on animal welfare. And so I know that you're also looking at legislation around animal welfare. And I think that they're really very, as Eric has mentioned, I have been watching the testimony on the other bill in this committee, and they're very compatible, and the work and showing up for I consider animals our constituents as well. So we're standing up for our animal constituents. So as mentioned, and I think Vice Chair Hango mentioned as well, there has been extensive testimony upstairs on this bill, and it's going really well. The pieces that we're looking at today that Eric will walk you through have been unchanged by the committee. And so I'll let Eric do the talking on that, but it's there's a few pieces that have to do with government operations, adding rulemaking authority to the Division of Animal Welfare, and expand the Animal Welfare Fund to be able to accept security paid in civil animal forfeiture cases. And Eric will walk you through that language. So essentially what that means is one of the pieces of the bill is when animals are seized, and we want to have Lisa, who's been in your committee quite a bit, be able to have the authority to have those funds come into I was just gonna call it the animal fund, but the animal welfare fund. So those are kind of the pieces that, because the director position is under your jurisdiction, she'll be able to, if we had that money going willy-nilly, it's not even a word anymore, going willy-nilly everywhere. So it was really in a contained space and so it'd be under Lisa's authority. And she has testified several times on the bill in judiciary as well. So now I would love if anyone has any questions for me before Eric really does the pieces that you can ask him about. But I'd love to open that up, Honorable Chair.
Yeah, you have questions from the member?
Crickets.
Seeing hands, we will just skip over to council then, I guess.
All right, well, thank you so much. And again, as I mentioned, I'm so grateful for the work that you all have been doing on these issues. And I think that it's great that Vermont is really stepping up for this constituency that so many people care about all across Vermont. I hear from folks in all parts of Vermont who are grateful that we're taking up these bills. So thank you. And our esteemed council.
Non-voting block.
No, it's true. They can't vote, but they're still our constituents.
Council.
Yes.
Can I ask a question first before I start?
Sure.
Yeah, thank you. Rep. Krasnow just said that there's that this bill asks for rulemaking authority for the animal welfare director and
Yes,
does some stuff and put the money for the animal welfare fund.
right,
And I believe that H 841 also does the same thing. So
exactly.
is there a reason to have it in two places? Is there is it the same language in both of them? Like, I'm just.
No, it's not the same language. So that's why I think from our perspective, when I say our, I mean, Ledge Council.
Yeah.
This happens sometimes that you have multiple committees making amendments to the same section of law, not same language or even necessarily the same specific topic, but they're working within the same section. So what we do amongst ourselves, in this case, often it's one Ledge Council attorney keeping in touch with another one because they're two different bills. In this particular case, they're both my bills, so I can check in with myself anytime and see, oh yeah, do I remember what happened in that?
Yeah. My own best collaborator.
Yeah, exactly. Collaboration will be easier that way. But the provisions, although they're in the same section, address different things. And so the way we ordinarily do that in our offices, we have the authority in statute to harmonize these things after they pass. So as long as they're not contradictory, which they're not in this case, but if that were the case, that would be a problem.
Okay.
But otherwise, now that doesn't mean you can't put them in the same language in both places if you wanted to, just in case. But it's funny that like it wouldn't. Sometimes we'll do that because you want language to be certain that it passes. But in this case, like you wouldn't want, but okay, for some reason, the animal cruelty bill upstairs doesn't pass, then you wouldn't want their provisions that are in the rulemaking and the Division of Animal Welfare. You wouldn't want them to pass on their own because they're dependent on stuff that's in that other bill. That's in H 578, similar to your bill, H 841. You know, the specifics of the rulemaking and the authority and the animal welfare fund are all sort of dependent on other parts of your bill. So they wouldn't pass standalone. So it almost makes sense in that respect, as I say it out loud. Keep them in their own bills for now. I'll keep an eye on both. And
Trust yourself.
yes, I will. I try. Not always, but I'll try. And then kind of going forward, I think that way you'll make sure that whatever passes in the end is consistent.
Okay.
That's kind of the idea. But you're right to flag it because that's exactly what I was going to mention in my testimony.
Oh.
So I know, totally. So yes, Eric Fitzpatrick with the Office of Legislative Counsel. As Representative Krasnow mentioned, there's a detailed animal cruelty bill that's been discussed for quite a while up in the House Judiciary Committee. For the most part, it deals with like 98% of it deals with the criminal code and the crimes of cruelty to animals, aggravated cruelty to animals. It expands the definition of cruelty to animals in a number of ways. I don't need to get into the details of that now, but that's kind of what happens in the big picture, expanding the type of conduct that can be criminally prosecuted. It also expands, there's a list right now of, in addition to criminal sanctions, other types of penalties that a court can impose on somebody who's been convicted of one of these crimes, like forfeiting their animal, not being able to possess the animal in the future, having to submit to random inspections, that kind of thing. So it's all existing, but it's worked on and expanded in the House bill, the House Judiciary Bill, which is 578. The piece that's relevant to you folks, there's a third sort of big picture thing going on in that other bill, and that has to do with forfeiture proceedings in the civil context. So under existing law, the way it works is, and similar to, you might have heard, like automobiles can be forfeited, proceeds related to drug crimes can be forfeited. There's other civil forfeiture proceedings in place in the law. This one involves forfeiting animals when a law enforcement officer has probable cause to believe that there's been a criminal violation. So it doesn't require conviction of the crime. You can have this separate forfeiture proceeding. And that piece is also being worked on as part of the House Judiciary Committee's bill. So what's going on with that piece that brings in some statutes in Title 20? The proposal that they're looking at is to add an element of the forfeiture proceeding, which is requiring the person who owns the animal to provide some security, basically a bond, some money. Because the issue they're trying to address is an animal gets forfeited. I'm sure this committee's aware of this from its work in the subject area over the last few years. An animal gets forfeited and there's going to be a period of time there, assuming they're criminally prosecuted, where somebody's going to have to house the animal and pay for expenses of care. So many times there's going to be expensive veterinary bills. There's going to be cost of feeding, housing the animal, all that sort of thing. And one of the major problems that this subject matter that is associated with the subject matter is, if the animal ultimately gets forfeited, the person gets convicted, who pays those costs? And evidently it's become very financially prohibitive for humane societies, animal rescue organizations, groups like that are running into financial problems because they have these forfeited animals that they can't pay to care for. So that's one of the problems they're trying to address, is how can they get some of that money? So they have this security process. So if somebody gets their animal seized, they are supposed to pay security in the beginning if they want to challenge it. If they don't want to challenge it, they don't have to pay anything. That's fine. But if they do want to challenge the forfeiture in court, then they have to pay some security. So that's the background. Why is that relevant to Title 20? Because, as Representative Krasnow mentioned, the process that they're proposing to set up is that the security is submitted first to the court, and the court then transmits it to the Division of Animal Welfare. And the Director of Animal Welfare is then the person who's responsible for making the security payments out to the Humane Society or to the rescue organization or to whoever it is that's been caring for the animal and has been incurring these costs. In order to do that, obviously, you have to have someplace to put the money. And that's why the Animal Welfare Fund also has an amendment in the bill, because the money goes to the division that then places it in the Animal Welfare Fund. And it's then, as I said, distributed to people that are incurring these costs. So those two things, the fund and the division, and the other piece is that the Division of Animal Welfare has to come up with rules as to how that whole process is going to work, and even a schedule. Like, because they were talking about how much it costs to care for an animal is going to depend on what type of animal it is, how old the animal is, do they need veterinary care? So the director is also supposed to have a schedule of how much, depending on all that. So that also has to be done by rule. So if you think for a moment back to the bill that I walked this committee through a couple of weeks ago, H841, Representative Waters Evans bill, that also had some amendments to the rulemaking authority, or proposal to establish rulemaking authority, and to the fund. And those proposals basically gave the division general authority to adopt rules, and specifically about outdoor cats. Remember that they had to do rules on outdoor cats and on the certified rabies vaccinator program. So those are the two things they had to do rules on. And with respect to the Animal Welfare Fund, remember a couple of other pieces that were in that bill, H 841. One was tax checkoff. Remember, so people can do a tax checkoff and have their money donated to the animal welfare fund. So that had to be put in the fund also, so they can hold that money. People do the checkoff and donations or gifts. So those two things were added. So the same statutes in the bill that House Judiciary is looking at, 578, also allow the Animal Welfare Fund to hold an additional type of revenue, which is security posted in animal forfeiture proceedings. As I just described, that too, that gets added to the list. And their rulemaking authority is also added to deal with these types of payments, collection and payment of security and developing a schedule. So it's in the same statute. It's even adding other elements to the list, but they're in addition to the elements that you folks have proposed to add in your bill. So it'll be easily reconciled, which is what our office would do. Assuming they passed in different bills, we'd reconcile them later on. So supplementary, but not contradictory or in any way problematic. But it's good for you folks to know because obviously they're proposed amendments to statutes that are in your jurisdiction, Title 20. That's kind of
That's the
summary.
The sections are,
In the House, in 578 of the House Judiciary Bill, those are sections 6 and 7, the very last 2 pages of the bill, page 30 and 31. So section 6 is the rulemaking authority for the division. And that's having to do specifically with receipt and management of security posted in animal forfeiture proceedings, as I mentioned, and to make distributions and reimbursements from the fund for animal organizations that provide custody. And then over on page 31, subdivision 3, the fund shall consist of, and it proposes to add security that's posted in animal forfeiture proceedings and transferred to the fund by the court. So those additions would be in addition to the ones that are in your bill, should that one pass as well.
did I see that? Router something.
Oh, yeah, I didn't have a question. I was just going to say, quite obviously, I'm fine with both of those things in this bill.
Thank you. So if this decision, the forfeiture is not appealed, then whatever is in the statute that we're building in this committee will take over for an animal that's going into the care of someone other than its owner.
If you mean the regulations on those organizations, like the statute that you guys are working on that has to do with, whether it's that the Division of Animal Welfare has the opportunity, I think the authority, if I remember correctly, to inspect those organizations, that sort of thing. Anything that's related to the governance of those organizations, yes, absolutely would be.
In terms of the House Judiciary Bill, if an animal is being seized, the owner does not appeal the forfeiture of that animal, its care would be covered under what we're working on in this committee with the Division of Animal Welfare.
Yeah, I think the organizations that care for them are within the statutory chapter that you folks.
I just
Yep.
wanted to make sure that that animal was going to be taken care of, even if its owner didn't contest the forfeiture.
Yes,
and didn't pay a security fund.
that's right.
Thank you.
Sure.
All right. I'm just scanning this one more time.
Sure.
No, it's pretty clear to me what the words are doing.
Right.
If I have any direct questions for you,
Sure.
I think it's more of a question for the member of the gallery.
Yes.
Do you have a timeline when, or an idea of when the Judiciary Committee is gonna try and wrap things up?
Yeah, so Chair Lalonde has indicated, I believe, to me, I don't know about you. He's hoping to only have maybe 2 more drafts, but We're very close. What ended up happening, as we all know, as members of this esteemed body, is sometimes you can open up some stuff, and so they really wanted to make sure they got it right, and so it opened up some different things that, so yes, it should be, it's my understanding that they will be moving this bill within the next week. Right?
I think that's the goal.
The goal,
Sometime
the
next week.
goal is to get it out so they can move on to other things.
Okay.
So within a week.
So, I'm personally comfortable with the language as it reads here, the purpose of us just doing a flyby on it. Does anybody have any concerns over the words, the two sections we're taking a look at? Okay, so.
Matched nicely.
I can certainly let you know if for some reason those sections get changed.
Yeah, let us know and we'll reevaluate it, but out of respect for the process and knowing that Chair Lalonde wants to get this thing moving, I'll ask for a straw poll on these two sections, 6 and 7. A thumb is favorable. All right, so that is, what is that, 7-4 or 7-0-4? Mhm.
8.
Eight, 8-3.
No,
That's why I'm a
8,
policy chair.
8-0-3.
Yeah.
We'll put you on Ways and
Money
Means
committee.
next.
I just did it by, it's Friday, that, I did that last week with a straw poll too, I like miscounted the table.
Yesterday.
But yeah, you miscounted, that was on a proper vote. You tried to put us down for a 12.
Thank you.
Thank you so much for your time.
Yes, no, of course, and thank you, council.
Yeah, absolutely. Any other questions? Let me know.
Certainly will.
All right.
Yeah.
So
Have a good weekend, you guys.
Have a good weekend and enjoy your Super Bowl Sunday if you so celebrate.
Yes. I just had to talk to the press about that. Exactly, that marketing portfolio.
Chicken wings?
Dude, that's actually what I do for the Super Bowl. I don't gamble, I make the wins. All right, so that one wraps that one up. And so up next, we are doing witness testimony on a bill we did a introduction walkthrough last week. H686, an act relating to expanding identification of certain lobbying advertisements. So I guess we'll just go down the list in order, if that's okay with everyone. We'll start off with Laura Hubbard, our Deputy Secretary of State.
You okay if I bring up Sean Sheehan?
I was just gonna ask if you two would like to do
We'd love
it.
to do that.
Awesome, let's do this.
And we have a meeting in 2, so.
Oh, yes, no, let's get you moving.
Okay. Good afternoon, Lauren Hibbert, Deputy Secretary of State. Thank you so much for having us in today. I'm very fortunate to be joined by.
Sean Sheehan, Elections Director, Secretary of State.
We love doing this double time.
No.
We got a whole stick down. And unfortunately for Sean, I don't do it only with him. So, oh, no, we are here all week. And luckily it's the last of the week.
Don't forget to try the.
So we are here to testify in support of this bill, from our perspective. And I'm going to ask Sean in a minute to talk a little bit about our office's role in lobbying activity. But from our perspective, we want to make sure that there's transparency. And I think this bill achieves that. There's just one potential issue that I want to flag, and I'm aware that there's a potential amendment. So if there's an amendment language before you, we would just want to have the opportunity to review that and make sure that it will work from a logistics standpoint, from an IT standpoint, and that we all understand that. I also would encourage this committee to consider having the Attorney General's office testify on this bill to make sure that it's enforceable. Everything that is in this chapter needs to be enforced by the Attorney General's office. So I think their perspective is really important. And the one thing that I think you may want to hear from our office about, again, is the impact on campaign finance. If lobbying activity is extended for the entire year, which is what this bill does, typically lobbyists do not contribute to candidates during this lobbying season. So I want to just understand a little bit more where that prohibition is, whether it's just practice or whether it is more expressly laid out in the law. I don't think that's the intent of this bill, to restrict campaign finance donations for the entire year for lobbyists. And if it were, that would be probably problematic with Citizens United. So I want to understand the origin of that. I haven't had time or really even the opportunity for Sean, even the opportunity to talk to Sean. He just came back from his national conference. So I want to dig into that, and we may want to either create an exception somewhere in the law that allows for lobbyists to give to campaigns when the legislature is not in session, or find out where that is in campaign finance law and modify that. I don't think the intent is to prohibit lobbyists from contributing to candidate campaigns, but just want to explore that a little bit more.
Totally understood, and that's a clear directive for us to dig into it a little bit more with understanding, so.
And I thought Sean might just want to talk about our role in lobbying, and what we do and our system.
Sure, absolutely. And so our, my division, the elections division, is a division in charge of elections, campaign finance, and lobbying. We had 3 systems for each of them. All 3 systems got new launches last year. I know folks at this table probably most familiar with the campaign finance system. It's there, and with the election management system, but the lobbying system was also launched last January, with our goal being to increase transparency, allow lobbyists to report their required activity, and for the public to be able to search for that activity by lobbyists, by other types of searches. From reading the bill, as I understand it, the lobbying system would be able to support it. Certainly the year round and the components there would just be changing the directions, changing the guide, changing how we instruct users to use it. And as the Deputy Secretary said, if there's other amendments too, we're happy to look at those, but we feel comfortable that the system is working well, and we can make tweaks as needed to comport with law.
The only piece there that I'll add is if there's large adjustments, it will have a fiscal impact on our office. So that's just the piece that we need to understand. We're now in the maintenance phase of our contract with our lobbying system, which means when we're making changes, not to get too IT technical, but it's a change request and there's a dollar amount attached to that. We haven't explored what that will be, if anything.
Yeah.
No, that's not too wonky. That's completely understood and appreciated as a reality of like you running your shop. So I respect that. Yes.
We at least looked at the bill at the way of just changing the date to not be the session. There wouldn't be any change requests.
Yes.
That we confirmed that with the team. That part is no problem.
But any other noodling could have a ripple effect.
It would be really like if there was specificity required on types of activity that were searchable or reportable as designated fields, that would be adding factors that we would need to explore.
Understood. Representative Nugent.
Could you talk a little bit more about the specific way that you were thinking that this might require? So it's just a notification. It's not prohibition on spending, right? It's just applying the same.
On lobbying spending, yes, there's no prohibition in this bill and expanding the time of notification to the state of lobbying activity. That it's not a prohibition at all. The piece that I am a little concerned about, want to explore more, and I hesitate to even bring it up because I haven't done my due diligence, but is on campaign finance spending by lobbyists, because lobbyists, I believe historically, and I don't believe it's prohibited, but do not contribute to any of your campaigns while the legislature's in session, because it would be seen as lobbying.
Yes.
And so I just want to make sure that we don't inadvertently make it so lobbyists can't ever contribute to any of your campaigns. I would assume that while some people would say that's very good, other people, including the Supreme Court, would say that's very bad. And so I just want to make sure that we are not getting our state sued. And so I believe that there should be a space where lobbyists can use their power to contribute to your campaigns under the law.
And there are the sections that speak to gifts and the pieces on that side, which obviously the law here, change on its face, wouldn't impact that. I think as Deputy Secretary says, this is the first we've seen each other in 2 weeks. We always seeing us together. It might be hard to believe we haven't seen each other in 2 weeks. But between
We've been in
conference there and me
contact.
coming back.
Poor Sean hasn't not heard from me every day, but we haven't seen each other, so.
So like within the, like that conversation, I'm like, if there are a ripple effect, it'd be a good opportunity to have council walk the committee through some of that stuff, just because we haven't really like delved into that in a long time. Just our knowledge base, Repstone.
I just want to say it is in statute.
It is in statute.
USA subsection 266.
I thought it was statute.
Yep.
I was like
It says
uncertain.
a registered lobbyist, a lobbyist employer, or a lobbying firm may not make or promise to make a political campaign contribution to a legislator, a legislator's candidate committee, or a legislative leadership political committee. And it goes on, but
So that would make it the entire year would not be able to do that.
correct.
And so that you may want to make an amendment to that
Yeah.
section,
That-
just so
yeah.
it's clear it's only.
That's where it is.
I remember that being a conversation in COVID year one, where the session ran deep into the fall and
Yes.
up against the election cycle, where that was a mechanism that restricted.
Constrained, yeah. So, yes, council, and we're happy to come back again on that specific issue since we oversee lobbying and campaign finance.
Of course.
And thank you, Rep Stone, for doing that legislative research.
Paul,
Could not do.
yes, Representative Hooper, Burlington.
So when a gavel hangs or at a session, no matter whether you're spending time on a summer committee or anything else that has you.
Currently, because of the way that the lobbying activity needs to be reported, it's in session. And that's what this bill is seeking to modify. And the restriction is no reportable lobbying activity to a candidate. And so because the reportable lobbying activity is the session and the section that Rep Stone just read doesn't expressly say in the session, I don't believe, but because the reportable lobbying activity is in the session, if you read those two together, lobbyists cannot give to candidates during the session, the way the law is currently. But the way this bill proposes, it removes in the session and makes it all the time. You have to report lobbying activity, which again, we support, but we just want to make sure that the campaign finance ripple effects are considered. And certainly if the intent is to prohibit lobbyists from ever contributing to candidates, I would just caution against that because of Citizens United.
I believe, someone can confirm it, they're in front of it, but I believe 266 does break out contributions from other forms of
It does.
gifts and other forms of activity. So it may already be covered in that. I think as Deputy Secretary is saying, we'll just want to look at it and make sure it's changed. Still secure.
So I just want to make sure it's governed by the in session, out of session, and not what the individual legislator.
I believe so, but again, this thought of this concern honestly really came in the last half an hour as I was thinking about what we were going to say. So, and was testifying in another committee in this time. So, it's just the nature of the day today.
Representative Stone.
No, there's a lot of gray area here and I support you in saying that the Attorney General should come in here for a variety of reasons. But would it be you who could answer, like, what is the difference between a campaign ad and a lobbying ad?
A campaign
A
ad.
campaign ad versus a lobbying ad.
A campaign ad is for a candidate or cause, and a lobbying is with the intent to persuade the legislature.
But what about a campaign, or can an ad about a bill that names the legislator look like a campaign ad? Like, I mean, I'm just thinking, I've been in some of those where it's like about H 1, 2, 3, then they list me and I'm like, okay, well, is that lobbying? Is that campaign ad? I mean, who would that be? You or Charity who would decide? Or
If somebody made a complaint, we would refer it to Attorney General Charity Clark. Yes.
That
Does that
Decision.
affect the 3 or more candidates? In publications or anything?
I'm going to say that I'd like us to come back and answer these questions because you're asking a depth of questions that we're not prepared to answer. And
Deputy Secretary had a great thought bubble on the way into the room. Let's refine the questions.
bring the AG in.
yeah, I think we should have a partnership on these questions. And I think these are really valid questions and ones that we try and answer every day. But again, we weren't prepared to do that. And
Yeah.
we would love to answer their questions. I just want to make sure that we're giving the right answers.
I'll hold my questions till we can get, because it was essentially the same thing of if you have a lobbying group that says these candidates supported this
Right.
bill, is that campaigning or lobbying? Because if I didn't ask them to use my picture, say if I'm on it and you're on it, and we're all on it, and they say, these representatives did this,
And then that could be,
and please support them,
or
but it
don't
wasn't
support them.
us, or don't support them.
That's more.
Yeah.
You
Depending,
know,
right.
that's more likely.
Yeah.
Is it can't,
And it
but if
depends
you
where
say
it's.
don't support them means you're campaigning for the opposition.
Right, and depending on who it is that's funding that ad, it could be, if it's coordinated with the opposition, it would be through that candidate. If it was through a party, it could be that. If it was not affiliated, then it could be an independent expenditure only committee.
Right.
PAC in that sense.
And so is that,
But it's certainly getting into the campaign finance side from the realm that you said when you're talking about candidates and clearly directing people to support or oppose those candidates, regardless of who's funding it, is going to fall into the campaign finance chapter.
because if I didn't ask for it or, you know,
Well, right,
found it,
yeah.
do we have to?
No, you went, that's when it would be the independent.
I want to be conscious of the elections
All right.
records, Deputy Secretary's time doing, but.
All right,
It's 2:00 clock.
I'm going on, yeah. Sorry.
The immortal words of David Hall, the only thing we know for certain is the list of hypotheticals is seemingly endless.
That is true. We rely on the brilliance of David Hall every day in our office. So
I miss relying on that.
yes. But I think we hear the essence of both of your questions, all three of your questions, and we'll do some research and come back. And I think also the Attorney General's.
Yeah, I don't want it to all fall on you because
Yeah.
that's
Yeah.
gray area. So I know.
We gotta talk to our council, we gotta talk to the AG, there's,
We'll try.
you gotta square the peg. Yeah. All right,
Okay. Thank you so much for having us.
thank you.
Thank you.
Thank you. Happy Friday.
You too.
Feels like a, you mean Friday?
Friday. I agree with that actually.
Thank you.
Yeah, come on up. Good to see you, Ben.
Good to see you. Good to be seen. For the record, Ben and Julie Walsh with the Vermont Public Interest Research Group, or VPIRG. I have a few slides that I'll share in a moment, but I wanted to just briefly speak to a couple of the questions that came up. Obviously, you'll hear from others, including your counsel, but in particular around the prohibition on contributions from lobbyists to candidates or solicitations from candidates to lobbyists. That is also tied in, as you noted, to VSA section 266 to final adjournment CNADA. The statute that 686 contemplates is also tied to final adjournment, but they're not tied to each other. So if 686 passed as introduced, it does not touch that prohibition on contributions or solicitation, because that is in an entirely separate part of the statute and would continue to exist as it does today. That is my understanding. So you can hear from others on.
Rev Uber Burlington.
So are you talking about the, come back for a because session caveat or considering that an adjournment that
I can tell you what it says in the statute. When General Assembly is in session until adjournment sine die. And I would suggest you hear from Counselor the AG's office on precisely what they interpret that. But let me pull up my. Let me see, I gotta share my screen. Can I have permission to share my screen? All right, here we go. Okay. All right. So I want to briefly go through from VPIRG's perspective, the problem or issue that H686 is solving for, and then touch on a couple of other related issues or clarifications that we would suggest you consider as part of this same bill as potential amendments. So one, what is this trying to solve for? You've already heard about this, so I won't belabor the point extensively. But obviously what this amends is the advertising, lobbying, disclosure part of the statute. And in particular, it removes the phrase at any time prior to final adjournment of a biennial or adjourned legislative session, just leaving at any time. Essentially, the problem that exists as we see it in current law is from final adjournment of the second year of a biennium through when you gavel in for the next biennium, there is no transparency around lobbying advertising. The typical requirement that if you spend $1,000 or more in something that is defined as lobbying and advertising, then you have to report in 48 hours that you did that, ceases to exist after final adjournment happens. And just looking at the last biennium as one example, that's almost a third of all of the days in that 2-year period. Obviously, it varies a little bit depending on veto sessions and all of that, but it's a substantial portion of time. And obviously, lobbyists, lobbying firms, et cetera, can still be doing things to try to influence legislative action, either in the subsequent biennium or, if the governor brings the legislature back, which obviously can happen. So the core of this bill, we believe, is a very good idea and would bring more transparency, more public awareness, and awareness of legislators yourself about who is trying to influence what. A couple of, actually 3 additional things that I wanted to flag that are related to this part of statute. One, this statute was last updated in 2015. And as you all know, how people communicate generally in the world and about legislation has evolved a lot in the last 10, 11 years. And as we read the statute, there probably are some types of lobbying advertising that are not currently included. In particular, the phrase "or internet websites" jumped out at us as we were reviewing this. I think if you asked the average American, is logging onto the YouTube app on your phone going to, quote, an internet website, you'd get a variety of answers. And a lot of people would probably say an app is not a website. So just for real clarity, we're proposing a few edits here. There are a couple of other similar definitions in other parts of law, including an electoral reporting law. And so looking at some of those things that could be very explicitly included that perhaps are being interpreted to be included now, but could be very clearly laid out are mass mailings, robotic phone calls, robocalls, and then or paid internet communications, to just be very clear, or paid electronic communications would be another way of saying it, that anything in that space counts. You're not talking about yes, you need to report the Facebook ads on somebody's internet browser on their laptop because that's a website, but no, you don't have to report the ones that are going to an app on their phone because maybe that's not a website. That seems like unnecessary ambiguity. And really, if this part of statute exists, it should be fairly all encompassing of the paid advertising for lobbying purposes. The next one is right now, and these are advertising disclosures that VPIRG as an organization certainly files sometimes. We also look at other entities. filings because we want to understand the playing field of what's going on and who's trying to influence who on what. And there is a phrase in the law that is right now very vague and results in vague and inconsistent reporting, even when it does apply. And that's this, the end of this section requires the reporting to include a brief description of the advertisement or advertising campaign. And the phrase "a brief description" is the only thing that is required in terms of what the description entails. So it leaves entirely up to the lobbyist or lobbying firm to decide what a brief description should mean. And I just looked at a handful of filings from the last 2-3 years, and here are some of the examples of what a brief description meant to the people making these filings. Some are clear enough. Ads in support of renewable energy standard, ad campaign opposing Act 18. Okay, we know basically what those are about. Online advertising. Advertising with VT Digger, which was in a filing where someone was paying VT Digger, so really didn't provide any additional information beyond what you already knew by the fact that the filing existed at all, and then just email blast. So if the idea is transparency, that phrase, "a brief description," we would argue is insufficient to actually provide transparency about these activities. So we looked at a few other states' statutes and consulted with some of our colleagues and are putting this out as a possible way of requiring a little bit more information in a way that would not actually, we believe, although you should hear from them directly, require any additional work on the Secretary of State's part. They wouldn't need to change their form other than maybe like changing some guidance, but they wouldn't need to like add additional fields to enter information on the form because you could just drop it in the same place that you're putting a brief description now. So we would suggest including the language, including the bills or issues it is focused on and whether the advertisement or advertising campaign expresses support, opposition, or neutrality on the bills or issues, so that you have some clear guidance as to what information we are trying to be, as a state, transparent about. And then the last one, and this goes to a different part of the statute. This is in the definition section of the lobbying chapter of 2 VSA. And this is the definition of lobbying, which you would look at when you're trying to figure out, to the earlier conversation, what's a lobbying expense, what's maybe an electoral expense, but not a lobbying expense. And what's highlighted in red here is language, and this was last updated in 2007, I believe. That is maybe a little bit internally inconsistent, and also, I would argue, potentially misses some things that in this day and age could be fairly common lobbying activities. So directly, so this is in A, the communication that a lobbyist would be doing orally or in writing. So that's what lobbying is, what's covered in lobbying. And then down at the bottom, it's more like a group like VPIRG hosting an event for our members and giving them the opportunity to communicate with their legislators. And there it just says orally, it doesn't include and in or in writing. So we would suggest striking both in A, the phrase orally or in writing, and in D, the word orally. One, so that those two are consistent. And two, because there are other types of communication that arguably are not either orally or in writing, that certainly could be lobbying. You could take a picture of a member holding a sign that clearly indicates a position, and that's not orally or in writing. You could send a video message. Maybe that's orally, it's a little bit ambiguous. Obviously, communicate with without any sort of additional verbiage in there, clearly encompasses any form of communication. And from our perspective, both as an organization interested in transparency and one that does lobbying, any form of communication that meets this definition of trying to influence legislative action should be included in the definition of what lobbying is. So those are the three additional suggestions we have beyond our strong support for the underlying concept in the bill. And I'm happy to answer any questions you might have.
Any questions for Ben on the slide deck?
I will say, like, thank you for those flags. It's appreciated. So we'll discuss that with council as we look at this more.
Thank you very much.
Yeah.
Appreciate the opportunity.
Yeah. Welcome. It's been a while.
Great. Hello, everyone. For the record, my name is Lauren Hurl, and I'm the Executive Director of the Vermont Natural Resources Council, VNRC, and really appreciate the opportunity to testify in support of H686 today to close this loophole around lobbying disclosures. And for those not familiar, and I haven't had the pleasure of being in this committee for a while, VNRC is the oldest statewide nonprofit environmental group. Our mission is to promote a healthy environment and resilient communities for all Vermonters today and into the future. And prior to my time at VNRC, I was the executive director of Vermont Conservation Voters for more than a decade. And in that role, did an extensive amount of both lobbying and electoral work. So have spent many hours with the campaign finance system, with the lobbying disclosure system, with lawyers, and like trying to sift through these areas of laws, and wanted to share just a couple examples of how this is playing out and why we think this is a good step forward in terms of really making sure that our system is not leaving Vermonters in the dark about who is trying to communicate with them and trying to influence their positions on various issues that people care about. So to share one specific example, and you might have already heard this one, but in the 2024 elections, we were getting word from a number of members all over the state who were sending us pictures of these postcards that they were getting from a group called Americans for Prosperity, an out-of-state lobbying company largely funded by the fossil fuel industry. And every group, of course, does and should have the right to communicate with their perspectives with Vermonters. But we were not seeing clear and comprehensive reports of all of this activity that we're getting, info in from all over the state that's happening. So we didn't know where they were being sent, what they were trying to communicate, who was getting them, how extensive this campaign was. These messages were being sent during election season. But because they were not specifically saying to vote for a specific candidate or against a specific candidate, they were really falling into this gray area of our laws. And as you've been hearing, because we are in that window when lobbying isn't reported, they also didn't need to be reporting it as a lobbying expenditure. And so, we're just very in the dark about what was happening. During this same election, Vermont Conservation Voters Action Fund ran a series of ads that similarly did not name any candidates. We're not saying to support or oppose a specific candidate, but we're looking to educate voters on climate issues. And for us, it felt really clear that our communication could potentially influence the election because this is an electoral issue of interest of voters. So we felt really an obligation to report it as an electioneering expense. The campaign finance system isn't really set up for that kind of reporting. It's all built around tying it to a specific candidate who you're trying to support or oppose. And so we kind of did this like jerry-rigged reporting where we were trying to put it up because we were like, this clearly should be known to Vermonters that we're doing this. We would hope other people would be reporting. But it didn't seem like we were obligated to report based on like what we were looking at and seeing that these other lobbying efforts were happening and were not being supported similarly. So if H686 were to go into effect, we could have reported that campaign potentially as a lobbying expenditure, and then Vermonters would at least know who's doing this communicating and what type of ads they're running and, understand kind of who's out there trying to communicate with them any time of year, including during election seasons, and really just fundamentally believe that we all have the right to know who is trying to impact and shape our views on important issues. So moving forward, the simple changes proposed in H686 will make sure that future campaigns of a group like VCV Action Fund or Americans for Prosperity are all being held to the same standard of transparency, and Vermonters can have a more complete picture of who is trying to communicate with them throughout the year. I do support the modest amendments to H686 that Ben Edgerly Walsh from VPIRG just laid out, just kind of being a little bit more clarity around the types of communication. So adding things like mass mailings, robotic phone calls, or paid internet communications or something in that description. So, those are all major ways that people are doing lobbying right now. So it's just clear that we want all of that type of activity reported. And then also just adding a little more guidance around what we mean by brief description so that we understand, you can have a sense as a Vermonter what people are trying to communicate about. And then also just what feels kind of like a cleanup around the definition of lobbying, that can be communicated in a variety of ways. And happy to certainly, if helpful, offer to work with the Secretary of State's office to make sure that if you all are interested in these amendments, that they can be done in a way that doesn't create any new IT expenses or complications. I think that's totally feasible. And there was no intention of this bill to prohibit lobbyists for contributing later. So if there is any clarification that needs to happen there, again, similarly happy to work on making sure that that's clear and cleaned up if needed. So, just to wrap up, we think this is a meaningful step for transparency. Everyone should have the right to know who's putting out lobbying communications at any time of year. We don't think transparency should end when the legislature adjourns. So thank you so much for taking the time to hear our considerations and hope to have your support. Happy to take any questions.
My commentary, right? Like I do represent Sevilla, who was working on this, that's going to speak to this issue once it kind of was identified off session. So I was coming into the year with a lot of intent to take this up in a serious manner. So I just want to say that to you folks clearly. And then I guess it is just sort of this thing we do with bills that are only a page and a half long, then all of a sudden there's this ripple effects. We just gotta suss it out to make sure that the buzzword of the building for years, unintended consequences, right? So be very mindful of that. I will say that we plan on trying to suss this out, and I do appreciate the other suggestions. So I'll stop. Any questions from the committee?
No.
We nailed the 2:15 desired end time for committee work.
Thanks so much.
Thank you.
Thank you.
That's a wrap for the week, folks. Good job. We got one big bill out. We got a couple other things.